An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. Morrison v. Olson, 1988. Morrison v. Olson involved a constitutional challenge to the Ethics in Government Act of 1978. To understand why this law was enacted, we need to recount the history of the Watergate scandal. During the 1972 presidential campaign, the Committee for the Re-election of the President, nicknamed by Nixon's critics as CREEP, enlisted several individuals to surreptitiously enter the Democratic National Headquarters located in the Watergate Hotel complex in Washington, D.C. What they were searching for remains a matter of controversy. Following the break-in, the men were arrested and charged with burglary. Nixon had no knowledge of or participation in the break-in itself. However, recordings of White House conversations between the president and his closest advisors revealed his participation in discussions about raising money to pay the burglars in return for their silence about who they were working for. This unsuccessful effort became known as the cover-up. Although the burglary and investigation were reported during the election, President Nixon's involvement in the cover-up was not disclosed until after he won re-election in a landslide victory. As evidence of Nixon's misbehavior mounted, the House of Representatives initiated impeachment proceedings on May 9, 1974. The Constitution provides a two-step process to remove the president. First, the House of Representatives shall have the sole power of impeachment. The House of Representatives approves by a majority vote articles of impeachment that charge the president with engaging in treason, bribery, or other high crimes and misdemeanors. An impeachment is like an indictment in a criminal case. Second, the Senate shall have the sole power to try all impeachments. After the House impeaches the president, the Senate functions as a court where the president is tried. When the President of the United States is tried, the Chief Justice shall preside. Removing the president requires the concurrence of 2/3 of the senators present. Ultimately, the House would never vote on articles of impeachment of President Nixon. Less than 3 months later, Nixon would resign from office following the aftermath of the so-called Saturday Night Massacre. In 1973, President Nixon had appointed Elliot Richardson as his Attorney General. In response to pressure from Congress, Richardson appointed Archibald Cox as a special prosecutor to investigate the Watergate incident. Mr. Cox issued a subpoena to the White House for the secret recordings made in the Oval Office. Under the regulations in effect at the time, Nixon could not fire the special prosecutor himself. Only the Attorney General could. On the evening of Saturday, October 20th, 1973, Nixon ordered Richardson to dismiss Cox. Richardson refused to fire Cox and resigned in protest. After Richardson's resignation, William Ruckelshaus, the number 2 person in the Justice Department, was elevated to the post of acting Attorney General. Nixon then ordered Ruckelshaus to fire Cox. Ruckelshaus also refused to fire Cox and resigned. The process would repeat itself one more time. After Ruckelshaus's resignation, Solicitor General Robert Bork was third in line at the Justice Department. Now, Nixon ordered Bork to fire Cox. As acting Attorney General, Bork agreed and removed the special prosecutor. Unlike Richardson and Ruckelshaus, Bork never pledged to the Senate that he would support the independent special prosecutor. This rapid sequence of events, which all transpired on Saturday, October 20th, came to be known as the Saturday Night Massacre. The saga was far from over. Shortly thereafter, Nixon authorized Bork to appoint Leon Jaworski as a new special prosecutor. In turn, Jaworski issued a subpoena to the White House for the secret recordings made in the Oval Office. After receiving the subpoena, President Nixon refused to produce the tapes on the basis of executive privilege and the separation of powers. On July 24, 1974, the Supreme Court ruled unanimously in United States v. Nixon that the president could not block the subpoena. Facing disclosure of the recordings, 3 weeks later, Nixon became the first president to resign from office. This history brings us to the facts that gave rise to Morrison v. Olson. During the Reagan administration, Assistant Attorney General Theodore Olson was alleged to have testified untruthfully to a congressional committee. After a lengthy investigation, the House of Representatives submitted a report to the Attorney General that Olson violated the law. This report triggered the appointment of an independent counsel pursuant to the Ethics in Government Act of 1978. Because the Attorney General determined that there were reasonable grounds to believe that further investigation or prosecution is warranted, the independent counsel statute required a special three-judge panel of the Court of Appeals for the D.C. Circuit to appoint an appropriate independent counsel and define that independent counsel's prosecutorial jurisdiction. Pursuant to this process, a three-judge panel appointed Alexia Morrison as the independent counsel. Olson argued that Morrison's appointment was unconstitutional because she was appointed by judges, not the president, and was not confirmed by the Senate, as he claimed was required by the Appointments Clause. This conflict gave rise to Morrison v. Olson. By a vote of 7-1, the Supreme Court rejected Olson's challenge. Chief Justice Rehnquist wrote the majority opinion. Justice Scalia was the lone dissenter. Morrison presented three important separation of powers questions. First, did the independent counsel's appointment violate the Appointments Clause? The Appointments Clause provides two paths to appoint federal officers, depending on whether they are considered to be principal or inferior officers. First, principal officers, such as ambassadors, other public ministers and counsels, judges of the Supreme Court, and all other officers of the United States, must be nominated by the President and confirmed by the Senate. Second, Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. The majority opinion determined that the independent counsel was an inferior officer. Therefore, Congress could vest the power to make that appointment in the courts of law. That is, the three-judge panel of the Special Division.
Appellant is an inferior officer because she is inferior in rank to the Attorney General, because she has limited jurisdiction, and because the office of independent counsel is of limited duration and tenure.
Therefore, the Special Division Court could appoint the independent counsel, an inferior officer. Justice Scalia vigorously disagreed. Quote, "The independent counsel," he said, "is not an inferior officer because she is not subordinate to any officer in the executive branch, indeed not even to the President." Second, did the fact that the independent counsel could only be removed for cause impermissibly interfere with the President's duty to take care that the laws be faithfully executed? Chief Justice Rehnquist found that it did not.
But we do not think that in this case the good cause removal restriction contained in the Act unduly interferes with the President's exercise of executive power and his constitutional duty to ensure that the laws are faithfully executed.
Justice Scalia responded that, quote, "Limiting removal power to good cause is an impediment to, not an effective grant of, presidential control." Third, did the Act violate the separation of powers by reducing the President's ability to control the prosecutorial powers wielded by the independent counsel? Again, Chief Justice Rehnquist answered that it did not. Quote, "Notwithstanding the fact that the counsel is to some degree independent and free from executive supervision to a greater extent than other federal prosecutors, in our view, these features of the Act give the executive branch sufficient control over the independent counsel to ensure that the President is able to perform his constitutionally assigned duties." Justice Scalia responded by turning to first principles.
In the dictatorships of the modern world, bills of rights are a dime a dozen. What makes ours work is a governmental structure, a constitution of government, designed by 55 extraordinarily wise national leaders over the course of a 4-month convention 200 years ago last summer. That structure was designed to prevent an excessive governmental power, which is always the first threat to liberty, from coalescing. To achieve that, 2 principles were absolutely central. One was the separation of powers among 3 branches. The second was an equilibration of powers, so that none of the 3 branches could become too strong.
What is so problematic about restricting the president's power to remove the independent counsel? Justice Scalia offers a textual response.
Article 2, Section 1 provides that the executive power shall be vested in a president of the United States. It says that the executive power, not some executive power, shall be vested in a president of the United States, not a president of the United States and others.
This approach is known as the unitary executive theory. Justice Scalia explained that under the court's decisions, this power can
be exercised by someone who is not entirely subject to the control of the president, a mini-executive, so to speak, with jurisdiction over a very small, although in my view, a very important area.
Though Justice Scalia dissented alone, after an investigation in the 1990s by independent counsel Kenneth Starr led to the impeachment by the House of President Bill Clinton, many came to see the wisdom and foresight of Scalia's analysis. He explained, quote, "Frequently an issue of this sort will come before the court clad, so to speak, in sheep's clothing. The potential of the asserted principle to effect important change in the equilibrium of power is not immediately evident and must be discerned by a careful and perceptive analysis. But this wolf comes as a wolf." The Ethics in Government Act that authorized Morrison's appointment had a sunset provision requiring its periodic reapproval by Congress. In 1999, Congress allowed the law to lapse.